On the 37th day of the trial against Dr. Reiner Füllmich, as the trial seemed to be drawing to a close, a new case was unexpectedly admitted. Once again, all motions for evidence were rejected, including a request to abolish the self-reading procedure and return to having all documents read aloud in court. In his closing statement, Attorney Siemund shed light on the behind-closed-doors discussions between the judges and lay assessors, revealing the evidence motions that had been dismissed. Two additional human rights organizations were on-site, monitoring the developments in the courtroom. Mrs. Henning, what do you expect from today's hearing?
Yes, I'm quite curious. New information has come to light. This means that a new case is going to be opened. This will likely have an impact on this case as well. I think we'll learn quite a few new things today, and what I would like to know, or know quickly, is whether this will be handled through the reading procedure, or if the public will be allowed to attend after all.
What were the expectations of the human rights activist Mr. Meyernoff from Berlin today?
I don't expect much, because the past 5 years have clearly shown that we are completely at the mercy of this situation. All the mechanisms that should intervene in these crimes against humanity happening here have been rendered powerless. That's why I have no expectations at all for today in the courtroom. It's entirely up to us. And this is also a call to everyone. Expect nothing. Take action. Start doing something, because all the instruments are out of order.
We're also curious to see what's in store for us. It was announced that a complaint will be filed against the judge. Now let's see what Reiner Füllmich has to say.
What do you have to say about the new allegations that were admitted?
Well, I only found out about this morning, and it seems to have suddenly come up. But apparently it's been in the air for some time. I've heard that somewhere. And I think this is a sign. I've also heard from others that things are starting to get a bit shaky here, that the court is maybe running out of steam, and that they're trying to do something to likely maintain the detention conditions. To me, it all seems far-fetched, just like in other cases, such as with Michael Ballweck and so on. It seems like the law is being bent endlessly here. In my opinion, they're doing whatever they want. Just based on suspicion alone, they can't do so much. You can see it in the other trials, like with the so-called roulette coup. For me, it's often the same tactic, and it's important to bring this to the public.
Good morning, Attorney Siemund. Will you be delivering your plea today, and have you recovered from your shock?
Well, I saw that there have been some new developments. And then I see once again how things work in this so-called rule of law. I get something like this from Yahoo. News with a protester wearing a thong over their head. Someone who is protesting the completely pointless masks. And then it says that the Göttingen Regional Court has to address additional charges of embezzlement against a former representative of the Corona denier movement. No one denied Corona. It seems like everything happening here can be taken straight from the Stasi handbook. I'm completely appalled, but my shock has passed. As you can see, I'm no longer shocked. I'm angry, and that's why I'm here today.
Can you give us a hint about what you plan to say to the court today?
Well, it will definitely be about my client's human rights. I will briefly address his health condition, which apparently doesn't matter here. Now they've even dug up additional charges after the 5th Criminal Chamber, to which this case was referred back, rejected them. I mean, can it get any more confusing? I have no idea what's going on in the minds of these people.
So, you don't know if you will have to present your plea today?
I don't think so, since there are new allegations.
I'll take advantage of the break, Dr. Misery. You stated in your submission that informants were infiltrated into the Corona Committee and that the donors are not the actual victims of the deception.
So, if we accept the correct interpretation, that the donors were in no way deceived, and that the complainants Dr. Justice Hoffmann and Antonia Fischer were infiltrated into the Corona Committee, then the question arises, why do these complainants suddenly come forward and claim they were deceived? What is their intention? Where do they come from? What is the background of these individuals? One should ask why they are officially working with state organizations. For example, the unlawful extradition of Dr. Füllmich from Mexico data. Are these people the same ones who cooperate with state authorities in other cases? We have seen this in other cases, such as with the NPD, or whatever that party was called. It was revealed that half of the members were informants, and that's why the party couldn't be banned later on. It seems something similar has happened here, and now we have the people involved, the ones who even filed criminal complaint. This case was initiated by people who were actually part of the movement. And the best part is they say that the Corona Committee should have hidden the funds or diverted them from the state. Why not? And in the ruling from the higher regional court, they say that writing emails and so on wasn't work. But what were the emails for? They were for raising awareness, something the government tried to suppress by all means.
Mr. Attorney Siemund, today you accused the Chamber of holding a secret trial. How did the Chamber respond to your request for the reopening of the oral proceedings?
They rejected my application. That's the purpose of a secret court, to keep secret what you describe, discuss, and decide. So, in that regard, not even the reading of the evidence request took place today, even though I insisted. But, well, I also filed a complaint. But you know how it works here. The applications here are informal, without deadlines, and ineffective, because there's nothing to be gained from this court anyway. However, I want to highlight one small aspect that I included in my evidence request today, which I consider to be extremely important and worth considering, because we have a client who is well over 60 years old. And I'd like to read you a part of a study by Wilderman, Anderson, and others. It's titled Solidarity Placement and Post-Release Risk Formally in Court. .I. In plain English, it's about solitary confinement with investigation and its impact on the risk of death. Recent research shows that inmates who are isolated for at least 1 week during their imprisonment have a 60% higher risk of dying within 5 years after their sentence ends compared to those who are not isolated. We have an inmate here who has been isolated for 4 months. The longest period of isolation that is legally permissible without it being considered torture is 15 days, and we are far beyond that. So we're dealing with detention conditions here that defy description, and, as my esteemed colleague will probably elaborate on shortly, have nothing to do with human rights.
How was the request for the abolition of these security measures responded to?
As I've said, what do you expect from this court? Every request for basic relief, whether for humane treatment or even just proper transport for our client, is rejected. Because this isn't a trial, it's a political vendetta against one of the key figures exposing the truth behind the Corona measures, which he revealed through the Corona Investigative Committee.
Mr. Karl Füllmich, you are the chairman of United for Freedom. What observations have you made today as a human rights defender?
This is my first time here. Of course, I have been able to observe the proceedings from a distance and find the human rights issues here very questionable. How these matters are being handled is concerning, and I have initially followed up on them from afar. First of all, I arrived yesterday to get a personal impression of how things are being handled, particularly regarding the treatment and the detention conditions, which we want to address. Siemund has already pointed out that there are glaring, life-threatening issues here that need to be discussed, for which the court will be responsible if it continues to behave as it has been, manonly ignoring emotions. From a human rights perspective, it needs to be made clear that this is about human lives, about individuals. Proportionality must also be maintained, and at some point there are limits to what can be tolerated. One cannot simply brush aside matters here with the attitude, let's discuss this here, let's discuss that there, while Dr. Reiner Füllmich is sitting there, being sent back into detention in chains. That is torture. Such actions are also unacceptable under international law. To restrain someone like that To humiliate them in this manner is also a form of human degradation. We have a number of points that we have worked out, and we will address them.
What options do you have as a human rights organization to intervene there?
I would like to provide a brief example. In preparation for today, we have already made contact with the United Nations Committee Against Torture. These are the avenues available to us. We are not reliant on German law, as Germany has signed these international treaties and is therefore bound by them. As a result, we are addressing the Committee Against Torture, which also operates within Germany. The National Prevention Mechanism for Torture is located in Wiesbaden, and we are currently awaiting the final report on this troubling matter. We still require some additional information, which we expect to receive shortly, after which we will submit it. Once the matter is reviewed, we anticipate that the relevant bodies responsible for the prevention of torture will intervene in the prison, conduct an investigation, and we will be actively involved in this process. However, this is not directly our responsibility. It is the responsibility of the Committee Against Torture, and we have already engaged them. As stated, we are awaiting our report.
Do you see a case of breach of trust here?
It is not our role to assess this. There are lawyers who are very experienced in this area and have been handling such cases for a long time. We do not interfere with that.
Overall, the impression was that the prosecution and the judge seemed to be in agreement, as essentially everything presented was simply rejected. You could tell from the outset that whenever the sentence started with the motion, it was clear it would be denied. It's as though that they're playing for time. Perhaps they aim to tire or wear down the observers, because now the only way to confront the state is through the courts. There are hardly any other avenues for contact, other than through the tax office and paying taxes. There may be many underlying intentions at play, and the prosecutor gives a very unsettled impression. But he doesn't need to say much, except fiddle with his phone. So, yes, one can do the job, but one has to consider what they're selling in return, perhaps their soul.
Ja, man kann den Job machen, man muss aber gucken, was man dafür verkauft. Vielleicht seine Seele.
Do you consider this case to involve the misappropriation of donations?
No, I don't see that. But I do see a completely different intention behind the proceedings. For me, the embezzlement of donations is basically just the pretext, and as a layperson, based on just this little bit of the trial, which is the first of 37 that I'm attending, I can already strongly deduce that there are entirely different motivations at play.
The defense team, what happens now after the break, and what have you prepared?
Don't reveal our strategies ahead of time, but what I can tell you is this. We are going to file urgent motions that cannot simply be swept under the rug, especially not with a flimsy excuse like relying on written procedures. We need to see how the court addresses the evidence motions and, above all, the motion my colleague submitted, Mr. Pohl, regarding the client's dire health condition. In my view, this cannot, under any circumstances, be postponed to some vague judgment weeks from now. You cannot just say, oh, here's another deadline for you to respond. Or worse, we'll deal with that in due course, maybe in the final ruling. The fact is, the client is currently enduring immense suffering, remains detained in isolation with his condition visibly and progressively deteriorating. Yesterday, we learned of a shocking development. The higher regional court, after more than 6 months, has suddenly admitted 16 additional charges against him. 16. This is no coincidence. It's a clear signal. They are determined to keep him in pre-trial detention, no matter the cost. He has no chance of release now, no matter what the verdict may be. The client's condition is critical. He cannot endure another day of this white torture. Isolation, shackles on his hands and feet, no sunlight, no exercise, and a diet that can hardly be called food. Yes, one might say, other prisoners deal with these conditions, but the difference here is the constant dehumanization. Shackled, treated as a walking target, told to wear a bulletproof vest because he could be hit by a stray bullet. It's no wonder he is now suffering from debilitating anxiety, convinced he is in constant danger of being shot. Where does this madness come from? No one will tell us. We've been fighting for answers since June 10. We filed a motion demanding clarity about this treatment. It's been ignored. They claim his health is fine based on nothing more than a casual phone call with the correctional facility. But let me be clear, this assessment means nothing. His condition must be evaluated by an independent doctor, not one employed by the prison, not one bound by its directives. What's happening here is a gross miscarriage of justice. And last week's disgrace, when Mr. Schröter suddenly couldn't recall anything. This cannot continue. The man is suffering, and every day they delay is another strike against his basic human dignity.
Do you still believe that the human rights organization involved today could be the catalyst for real change?
Hope, definitely. Personally, I still need to have a more detailed conversation with them after the trial. I didn't manage to do that during the lunch break. I would really like to meet them, and I definitely hope that they can make a difference in their field.
Mr. Attorney Siemund, with all these motions regarding the condition of your client, the corporate legal perspective seems to be somewhat sidelined. Do you still hope that this will become a topic of discussion?
Honestly, I have no hope that the corporate legal perspective will become a topic at all. At best, it might come up in some closing argument I'll give, maybe at some point in the future, because right now, I don't even see how I could present a closing argument. But we've really prepared ourselves today. We even brought a printer so that we can submit written motions and challenge the principle of orality. This is it's outrageous. The constant violation of our rights and being dragged into this as co-perpetrators is absurd. I almost feel like I should stand up, loudly read out my motion, and get myself thrown out of the courtroom. But that won't happen. Neither one nor the other. Even though, if it came down to it, I would still consider that as a last resort. As I said, I'm appalled, but as always I remain hopeful that help might still come from an unexpected source, from a place we haven't heard from yet.
What is your impression of the statements made so far?
The previous statements were good and offered valuable insight. But now, being sent out again under the pretext of protecting the personal rights of a complainant feels peculiar, to say the least, if not downright baffling, especially considering that this very issue was openly discussed during the main trial earlier, with the public present and fully able to hear it. The inconsistency is glaring, and it raises serious questions.
Ultimately, it comes down to interpretation as to why certain actions are being taken in this manner. I am not in a position to definitively assess whether this constitutes a deliberate delay on the part of the court or simply standard procedural steps that the judge is obligated to follow.
I've come to know this all too well from Poland. A person can be broken, physically destroyed, while the so-called rights of certain individuals are allegedly being protected. I don't know what kind of show this is, but it has absolutely nothing to do with German jurisprudence or the rule of law anymore. Not at all. And I can't help but wonder when the people still living in this country will finally wake up.
Attorney Dr. Misery, what conclusion do you draw from today's proceedings?
You can't really draw a conclusion from this. Part of the closing argument has been presented. They'd say it was a good day.
Yes, it continues. That was quite the statement. I'd say it was a solid closing argument. From what I gathered, Attorney Siemund also wished the prosecutors a nice day. Gentlemen, it almost felt like he was saying, all right, buckle up, because the winds are about to change.
Yes, today was a very exciting day, really thrilling. Finally, things moved forward in a way that was understandable for the public. I thought Attorney Siemund was excellent. He read out things that the judge had previously rejected, and even incorporated those procedures into his argument. And he did it so cleverly, weaving it into his closing statement, which I don't think is even finished yet. I really liked what he said. It was also deeply disturbing to hear the reports about the health condition and this white torture. I mean, 12 points that define white torture. That really made an impact on me. Today was a very gripping day, and I'm still frustrated that Reiner hasn't been released yet. I really wonder what needs to happen for that to finally take place.
Attorney Siemund, looks like you didn't quite finish your closing argument today. The court's calling it a day. How much longer do you think you'll be going?
At this point, I have only read to the court and the public what has been discussed in private sessions today. I am considering whether to incorporate additional motions for evidence, which were not previously read out, into my closing argument, as many of them address points I must address in my plea. The fact that I now have the ruling from the higher regional court allowing the opening of the other proceedings is, of course, significant, although I find it entirely absurd. Nevertheless, presented it today. At several points, I could only shake my head, as I seriously question the reasoning behind such decisions. The assertion that no contract existed, honestly, why would he have done that? He has rendered services. However, I will need to carefully examine this further.
Are you referring to the new accusation against Füllmich?
Yes, I am referring to the new accusation, but I need to review it carefully first. The new accusations from the higher regional court do include many aspects that are relevant to my case, such as the business judgment rules or the issue of management without a mandate. While the matter of loan agreement, it is still an aspect that plays a role here.
How do you assess the interruption by the court? Were the secret diaries of Justice Hoffman and Antonia Fischer presented?
Well, there were some personal references in those passages that I wanted to read out. Of course, the chairman intervened preemptively. We also discussed whether a passage, which had already been addressed in the oral hearing or during the witness examination, could still be read out. But here too, the chairman said that repeating the violation of personal data was a reason to stop the reading. Was he perhaps right in doing so? We didn't examine it. We just accepted it because it wasn't really a decisive or significant statement that was withheld from the public.
Are you satisfied with today?
I am very satisfied. We showed ourselves to be combative. We didn't just accept everything. That's very important. We are increasingly pushing for our client's health condition to be brought to the forefront. Why? Because the current prison conditions, 12 months in jail, 4 of which in solitary confinement, are unacceptable. Today, I read the key passage in court. I think I already mentioned it earlier in the interview. Health risks arise when someone is in solitary confinement for just 15 days. And the risk of death increases by 60% over the next 5 years. Does anyone need more to release someone after 4 months of solitary confinement?
In your plea, you spoke at length about Reiner Füllmich's life circumstances before the corona period, which doesn't really correspond to the time period in question. To what extent is that relevant?
Yes, that is certainly, I would say, not an insignificant piece of information. Also for the court and the lay judges. Well, because, as can be read in the decision of the higher regional court, none of them has yet seen a single broadcast from the Corona Committee, so they needed to know what kind of man it is who stands there. And after, I would say quite openly, after he made millions from exposing banking fraud, he makes his future dependent on being active in the Corona Committee. And then, when it is expected of him to do it for free, that is certainly not appropriate. This was never what my client wanted, because in any case expenses must be reimbursed. Also, the fact that from the beginning there was actually the belief that in a few weeks this would be over, because what was being presented was so devastating that no one would consider the government's measures to be appropriate anymore. It was never foreseeable that this would turn into a years-long reporting process. Not only that, but also contribution to scientific understanding in this field. That it would become what it is now, no one could have predicted, and no one can expect it to be done for free. I'm also sure that none of the donors expected that. That Justice Hoffman and Antonia Fischer expected, I understand, because when I get involved and later want half of the pie, of course, I have no interest in anyone really earning something who has actually done something for it. But well, that's the moral of today's session, which we've worked out. Our client, I would say quite openly, is actually a very wealthy man who has more or less deprived himself of his fortune through these corona matters. Yes, because the whole thing simply cost money. And at the end of the day, we'll see whether it was a disadvantage for him to do this, or whether he said, I did everything for the clarification, I would do it again, and what I did beforehand gave me the opportunity to do this. That was also the reason, for example, why Justice Hoffman always said, I need money for this reason, very clearly, because he didn't make any money with his law firm. And when he doesn't make money, he looks where he can get money from. Where could he get money from? From donations or from the gifts that were made? Because I still don't consider it donations.
Let me jump in here. You quoted a sentence, namely, if you want us out of this, then this is the price you have to pay. From whom did this sentence come, and what price is being referred to here?
Well, that was in the context of the so-called termination agreement. In my view, Justice Hoffman and Vivian Fischer, without even being members of the company, tried to dissolve the company and liquidate the available cash. And in that context, he said, yes, if you don't give me the money, I'll stay in. Otherwise, you'll have to pay me to leave. In my view, he had already long been out of the company. But that's Justice Hoffman's perspective, which he still denies to this day in this court, claiming to be a member of the Cooperative Limited that no longer exists. And I find it completely baffling why the higher regional court continues to follow the same line.
There's been some confusion regarding your last statement, that these are not donations, but gifts. Is it correct that the Corona Committee could do whatever it wanted with the donations?
No, that's of course not correct, because we all know what this was about. It was about education, raising awareness. I've explained the difference between a donation and a gift. In my view, the committee was obligated to provide education, and that happened. This task was fulfilled, and more than expected, because I don't believe anyone could have foreseen the extent, duration, depth, and precision of the clarification that took place here. So many know-how on a single day. Yes, what could have flowed into the company in terms of scientists and know-how if the media had supported it? That's something we've never seen before, and that's exactly the problem. It became clear that this society, this large committee, was able to explain things that would have shown that the government's measures were completely absurd. And that's why everything has to be stopped here. And that's why it's also being claimed that Dr. Reiner Füllmich somehow embezzled the money. That's complete nonsense to me. He simply used the money to do what he was supposed to do, provide education, and that included, and I must say this in anticipation of what has now been further revealed, answering the questions from the people who came by the thousands. And that was no easy task, because it was ultimately about education in individual communication, not just through a channel or on TV, whatever, but in the form of answering emails. And that's a huge effort, where people have to empathize. Many may have had problems. I don't know the emails in detail. And then you have to address them. And that's a massive undertaking. So, I can't understand what could possibly be criticized here.
Has any financial damage actually occurred? Or let me ask it differently. Could the education or enlightenment have actually been insured by the company?
I don't understand how anyone could think that the enlightenment provided by the Corona Committee wasn't insured. But of course, it's important to say that this enlightenment was person-dependent, primarily led by Dr. Reiner Füllmich and then by Vivian Fischer, who both sustained this committee with varying levels of dedication, although I can't precisely assess if both put in the same amount of effort. Meanwhile, Antonia Fischer and Justice Hoffman contributed nothing but still want to claim half of the pie. In my view, this is something that doesn't make sense at all, because if someone hasn't fulfilled the purpose or the intended use of the funds for the awareness campaign, they have no claim to the money.
What about the severance agreement that the company had tried to make back then, which is also part of the file? Why has it not been addressed by the public prosecutor's office to this day?
Quite simply, because it's a poison pill. If one were to examine what happened there, one would come across several things. One is that if an attempt had been made to liquidate the company's assets, the intended use of the money, which was for raising awareness, would no longer have been pursued. And that would have been a problem, because then two partners could have transferred money to themselves that they had no claim to, since they were supposed to contribute as partners. They didn't contribute, and therefore they have no claim to the assets. But this has the consequence that it could have been an attempted misappropriation, because then the purpose of the money would not have been pursued by the two partners, and they still would have profited. That's not acceptable. It's a double standard, and therefore the public prosecutor's office must be asked why they haven't investigated this matter as well.
Following your plea today, I will, for the sake of completeness, quote a passage from the public prosecutor's statement made 2 months ago, in which it was asserted that the purpose of the Articles of Association is not to finance the private life of Dr. Reiner Füllmich.
As I said, Dr. Reiner Füllmich's private life was not financed, because the money was not spent, but instead constitutes a loan that must be repaid. This means there is a loan liability outstanding, which is owed by Dr. Füllmich. In other words, this is not simply money that was wasted, but rather money that was spent within the framework of a loan agreement, which is entirely normal. And if, for example, this is considered in conjunction with the dissolution agreement that was supposed to be concluded, it becomes clear that the payments to the other two partners, namely Antonia Fischer and Dr. Hoffmann, for the financing of their private assets, would be permissible. This is a contradiction that the public prosecutor should explain. But I will say this, had there been a dissolution, I would be very interested to know how the public prosecutor would have acted. Would they have also brought Antonia Fischer and Dr. Hoffmann before the court? That is something I would like to know.
Thank you.